2022 सुप्रीम कोर्ट ने जजमेंट आया, which is whenever justice Kumar Sabha till limit to open. It is the finding of the court that justice is done is not should be on the assumption only, sir. सर हमारा सामने जो assumption जो विधि कहना रहता है, इसमें हमें ऑनरेबल हाई कोर्ट ने मैंने जो बिल कंटिन्यू करी आता है, वो क्लियर करी जाती है। I was abroad because by the order of honorable justice. Because assumption I have shown that the court is biased on me by the rules come and the order passed by the courts. That's all. Please.
तारीख 21 तारीख
वो किसी डेली पूरा सामने पहले ऐसा था फोन कहीं सच्ची बात बोला है उसकी ये है ना प्री प्लान मारे अरे दर्द नहीं करो
પણ 326 જ છે મેજિસ્ટ્રેટ કન્ડિશન
आफ्टर दैट जोड़े जोड़े बताई करना
આપો એટલે કન્ડિશન કયો 12 હવે હું તપાસ બાકી એમ 326 છે એટલે માથામાં ઇન્જરી એટલે અમદાવાદ જિલ્લામાં તો નહીં એનો તાલુકો કયો છે એટલે ગામમાં ધંધુ કામ નહીં કે બે ભેગા છે તો આજુબાજુમાં એટલે ધંધુકા તાલુકાની યાદમાં નહીં પ્રવેશ કરે અલ્ટિમેટલી મેજિસ્ટ્રેટ ટ્રાયબલ
of 2013 જેમાં બે કન્ડિશન ઇમ્પોઝ કરવાઈ હતી C અને D. Page number 12. C is shall deposit the passport and D shall not leave the limits of India. Now, for paragraph 16 is the prayer clause and page number 12 for our those are the two conditions. Page number 1 to 12.
Your fare is up to 28.
Sorry,
Your prayer is for up to year 2028.
Lordship. I understand that, Lordship. What is transpired is that after the order of this honorable court in the regular bill application, I got a job with US based company in the recent times. Yeah, I've been working for that company. So if Lordship may peruse, sir, page 102, order in CRMS 666 of 2024.
Hmm.
This honorable court was pleased to grant me passport. MR internal chillo page, internal page 6, page 102.
Hmm.
This honorable court was pleased to permit me to go to US and for a period of 6 months. That subsequently was modified. The very next page, order of the Honorable High Court of 4/4/2024 for a further period till 31/5/2025. Now my work for the US based company in the meantime got extended. So if Lordship may peruse page 107. એમાં સાહેબ ઉપર લખ્યું છે કેબ જેમિની માર્ચ 3, 2025, પેજ 107. Dear Samar Kumar so and so, we are pleased to confirm extension of the temporary transfer from Capgemini Techno Services Limited India to Capgemini America Inc. with an assignment extension start date from May 13, 2025 to June 13, 2027. Now for this, if Lordship may further peruse page 117. The US-based company, on the behalf of applicant, was pleased to make an application before the US Customs and Border Protection that we really require his employment, and that is why they, on the behalf of the applicant, made an application to the concerned authority over there that his work permit may be extended, and his work permit is extended up till 2027 June 13 June 2027.
Hmm.
So because of this particular assignment which he is working on since past couple of years with the US based company, he frequently has to visit USA, and that is why the prayer up to March 2028. If Lordship may he has been granted passport on various occasions by this honorable court as well as honorable high court. He has never flouted any of the conditions mentioned in the bail order or in the passport order. He has to frequently visit USA for this particular reason, as he is working for a company whose head office is in USA. His project is as of now situated.
ચાલો તમારે
આપે કહ્યું છે નામદાર કોર્ટે ક્વેરી કરી 28 સાહેબ એમને દાદમાં સી and allow applicant travel USA for work and travel to France in the month of October 25. એક જ મહિનાની માંગણી. Relief C. મળી છે? And allow the applicant travel to USA for work and travel to France in the month of October 25 for his training purpose. બસ એમાં વાંધો નહીં સાહેબ.
So on and off he has to visit USA. There's a genuine reason. Even the US authorities, they have specially made an application on his behalf, and again, as on the cost of reputation, he has now never flouted any of the conditions. He is present as and when.
we don't go by US regulations. We don't go by US regulation. We go by our own.
For the sake of clarification, that why this prayer asked by me, even if Lordship does not permit till March 31st, then at least till that is the visa which has been granted. That is
Why you want to go and work for US?
Lordship, it's
Then
a-
they are
No,
imposing
So
tariffs.
he used to work for Capgemini India, but the project is specifically based in Capgemini America. That is why he has to.
We work for Indian projects.
Lordship, that
Oh.
this is once in a lifetime opportunity for him, because it's a.
Why it you
that's-
there are lifetime opportunity in India? Why do you want to go to US?
It is the course that.
They are sending us back. and you want to go there,
Is-
and at the recommendation of US. Stay here, go France, we are not telling
No,
no.
training matter, that is specifically for training, Lordship, which the
You
company
can
is
get
sending.
training anywhere in the world now.
That's the, thank you, sir. He's been working on that project. That is why the specific extension at page 117, and that is why they have made an application rather than.
If they are making recommendation, ask them to give you citizenship of
Got it,
US.
okay.
Oh, they would be so kind for you. If they are sending recommendation letter, then ask them to give you citizen.
Got
ચાલો, up to, ચલો 3 મહિના.
એક મહિનો ઓક્ટોબર 2025
My request is that.
એમની માંગણી જેટલી છે
અગાઉ બી આપ નામદાર
ઓક્ટોબર 2025
પછી વરસ already
એ
આપેલા
તો ત્યારના સંજોગો હશે એટલે આપ્યા હશે.
ના સાહેબ, same જ સાહેબ, because he used to work for
he prayed
US
for
with-
only October 25
બાકી prayer એવી નથી, ઓક્ટોબર specifically
એને તો
France
બધું
because
છેક લગી
training-
અરે એવું સાહેબ કેવું હોય
31 ડિસેમ્બર 2025 સુધી.
હવે હાલના અરજદાર છે સાહેબ હાર્દિક ભાઈ ચાર્જશીટ થઈ ગયું સાહેબ તમારા સાહેબ પેજ નંબર એફિડેવિટ નું
આવા દો ને, આવા દઈએ.
હાજી વાંધો નહીં
Yes. Yes.
Now, he was not an accused in the schedule of. He was not an employee of this Jampa as the accused number one with the principal accused. But allegations against him that he received 40 lakh rupees from the accused number one for a lending. I was a broker between accused number one and accused number six. For that part, I received 30 lakhs, of the 30 lakhs, 11 lakhs was towards the repayment and balance 19 lakhs was given for the lending. Now, this entire complaint does not say even a line that I had a knowledge.
You were a broker
I was a broker.
and you
In that
received,
case also says I am a broker.
30 lakhs from accused number one
One,
towards purchase of,
lending with the accused number six.
from accused number six.
Yes.
Yes.
Therefore, this is my first contention that I am not an accused in the schedule of offense. I was not named in the ECR also.
Hmm.
The ECR I was not named as an accused.
Yes.
While filing a complaint statement, I have been made an accused, but now the kind of is a complaint, there's a role against me. It's on page. Page 14 of the see, there given a table.
Hmm.
First,
Yes.
page 41 of the PMLA.
Complete. Yes.
the process of crime with respect to Satyanarayana Jaju. I will number 4.
Yes.
File Act on 13/10/2009. Now, can you mark these dates because the case relates back to 2009. You will have to read the section as on that date of the PMLA.
Hmm.
His offense is committed on 2009. So whatever the sections on that day will apply, not the amended section, because there was the amendment in section 3 as well as the definition of process of crime. So the amendment would not apply. Therefore, I am requesting the court to mark the date. On 13/10/2009, there were the two amounts, 5 lakhs and 15 lakhs and 10 lakhs on 15/10/2009 were transferred from Mr. Sai Prasad organization. So account for so. Now that Satyanarayan Jaju, having his account with the Bank of Baroda, Bharat so should receive 30 lakhs from Sinai, and that 5 lakhs was given to the Vikram J. Choksey, accused number 6. 10 lakhs has been invested with the Romta Rising Stocks Private Limited, and 3 lakhs has been seized by the ED, which is in the custody of the SP under the order of this honorable court. Under section subsection 7 and 8 of section 8, this honorable court has passed the order subject to final outcome of this. So that amount of 343,613 has been seized, attached, and has been disbursed to the SBX subject to outcome of this petition. Now, except this, there is no allegations against me that I received this money and I transferred against him. Now, can you see Musoba respect the role, what they say in the complaint? Page 70. One paragraph is devoted to me.
Yes.
Sri Satyanarayan Jaju has concerned himself in received rupees 5 lakhs on 13/10, 15 lakh and 10 lakh on 15/10 from State Bank of India account of Mr. Sai Prasad Organizers Private Limited for a land deed that struck. Now that was I think their own case is the land struck between Dinesh Jalpara, Director of Sai Prasad Organizers Private Limited, and Sri Vikram J. Choksey. He has further transferred an amount of rupees 5 lakhs from his bank account to the account of Sri Vikram J. Choksey on 15/10/2009 and has in all transferred 15 to 16 lakhs to Vikram Choksey. He also invested an amount of rupees 10 lakhs with Romta Rising Stocks Limited on 16/10/2009. Therefore, he knowingly involved himself in the process and actively connected with the process of crime, including its concealment, placement, layering, and integrating in market, and has therefore projected the same as untainted. Now, there is no averment that by committing a crime, accused number 1 transferred his funds to my account, and I had a knowledge that he committed a crime. I was a broker only. As a to park the money till the deal is finalized, money was transferred to my account. From there, 15 to 16 lakhs I have transferred to this victim. Now, can you see the statement of these 3 persons, my lord? Before that, can you see page number 31 is the ACI here? What's complaining partial page number 31 of that? Annexure C.
31.
So the attached to the complaint itself. That bold handwriting hand in hand start from page 1. And it's separate bunch. You can see page 31 of that That is an ECI here, which was registered on 23/11/2010. Now can you see column number 5? The name of the accused, the 5 accused has been named: Manoj Gupta, Dinesh Jalpara, Himmat Bhai Patel, Rajesh Jariwala, and Sai Prasad, and number 6, any others. Now can we see the next page, page 32? In the table, in serial number 3, they have shown us that I received 30 lakhs rupees. So it was not unknown to them or something what was found during the investigation that I received the money. That's not the case. So from day one, they were aware about the receipt of the money by the deputy. But in spite of that, there is no evidence in the entire charge sheet, even prima facie, to at least that I had a knowledge that these 30 lakhs which were transferred to me were of the crime money. That is not the allegation, that is not the evidence, that is not in our hand. So I did not have a knowledge that what is the source of the fund. If I had no knowledge, then I cannot be made an accused. So this was a routine business transactions. Because earlier I lent him the accused of 11 lakh rupees, which I was to receive it back.
Yes.
And that is accepted in the affidavit reply also that the profits of crime is 19,50,000 only. Then I'll come to the reply later on. Then, so therefore, Kali, the 3 statements would be relevant for me: my own statement, statement of Dinesh Jalpara, and statement of Vikram. Watch me see those 3 statements. Then I'll take my submission for facts.
What are the page numbers?
The Dinesh Jalpara starts from page 65. I'm reading relevant, not the entire statement, my not page.
Only relevant.
Yes. I'm aware. Now that this statement is very lengthy, but for me, it's concerned on page 70.
Yes.
The parents is over in the middle. સત્યનારાયણ જાજુ પોઈન્ટ્સ મને પડે તેને 35 લાખ આપેલા છે. Now this is what is specific તમે આપ્યા છે. સત્યનારાયણ જાજુ મારા મિત્ર છે અને તેઓને 35 લાખ SBI ના ખાતામાં આપેલા છે. Now there is no entry of 35 lakhs in my account. So the entry is of 30 lakhs only. So this first statement is wrong. અને તેઓના બેંક એકાઉન્ટ બેંક ઓફ બરોડા અકાઉન્ટમાં આપેલા છે અને હજુ પણ રૂપિયા પાછા આપેલા નથી. તેઓ રોડ પર વાસુદેવ અપાર્ટમેન્ટમાં 11 માળ પર રહે છે અને ભટાર રોડ પર વાસુદેવ અપાર્ટમેન્ટમાં 11 માળ પર રહે છે અને ભટાર રોડની બેંક ઓફ બરોડામાં સ્વયંસો અકાઉન્ટમાં મય આપેલા છે. That's all. Mine sir kon hata tene sabotage another question. That's one question only. That's a Dinesh Jalpara. Now the his statement with respect to 35 lakhs is incorrect. There is no questioning by the investigation officer why you made a payment.
Because at the time of registration of the EC area, they were aware about this offense. Still no questioning on this line. There were transactions from my account to his account prior to that. There were checks which were bounced, which I have produced with the separate list exhibit after filing the application. Because this matter was earlier heard twice. At that time it was argued, the information shown, it was adjourned for taking instructions. On the aspect of why those figures are not there. Now then is the next statement. Of mine at page 83, ma'am. Annexure K.
Yes.
The short signal read is entirely to make myself clear. Second paragraph. My name, age, address, and other particulars are correct. I am married, and my wife name is so and so. I am engaged in broker of land. That is what I was to draw my attention. I am engaged in a brokerage of land and real estate business, and so and so, so and so. Then I'll come to state question number 1. How do you know Ms. Sai Prasad Overseas Private Limited? I state that I am engaged in real estate business. I came across it Dinesh by Jalpara, director of so. In which bank did you have bank account with? I state that I have the bank account with Bank of Baroda branch and account number so and so. On seeing the statement of your bank account, it is noticed that you have received 5 lakh rupees on so and so, 50 and 20 on so and so. And what for the amount was received? I state that Sai Prasad Organizers Private Limited from their account with the SBI Ahmedabad branch Surat had made RTGS transfer of the said amount in my account with Bank of Baroda. Say Dinesh Jalpara of Mr. So and so had transferred to the said amount for a line deal that struck between him and one Sri Vikram J. Chauksy of Badoli with a direction that I should further transfer the amount from my account. Accordingly, I have transferred rupees 5 lakhs to Vikram Chauksy on so and so. In all, I have made payment amounting to 15 to 17 lakhs to Sri Vikram on the directions of Sri Dinesh Jalpara, who had entered a land deal with Vikram, and I got the brokerage. I also state that rupees 10 lakhs was invested with Romta Rising Stock Limited on 16/10/2009, for which I would further submit details and have not earned any profit. Did you know Sri Dinesh Jalpara have cheated? Now, and this question is important. Did you know Dinesh Jalpara had cheated the state SBI Salavatpura, for which he was charged by CBI? I state that CBI Mumbai had also made me a witness in the charge sheet, as I have unknowingly received 30 lakhs from so and so. Dinesh Jalpara, being as a director, asked me to transfer further to Vikram Chauksy for a land deal that struck between the two. I also state that I came to know that the amount transferred to my account were profits of right and needs to be attached under circumstances. I further stated I would bring Vikram Chauksy, who was also given a Toyota Camry car. Then this further questions are not still I'll complete.
Yes.
Dinesh Jalpara give any amount other than the 50 lakhs as mentioned in the CBI charge sheet. I state that I have not received any other amount in any form other than 30 lakhs from Sri Dinesh Jalpara, and I agree to the fact mentioned under the CBI charge. So 35 lakhs for the Dinesh Jalpara said is incorrect. And the proper details that is my statement is wrong. Then can you see the next page, page 85 is the statement of Vikram Chauksy.
Yes.
Now can you come to the, I'll come straight with the questioning, my lord. The short statement again. One page. how much amount of money has been received by you from Sri Satyanarayan Judge? I have received rupees 15 to 16 lakhs from Satyanarayan Judge. Looking into the bank account statements in Satyanarayan Judge, I also stated I have received 5 lakhs from so and so out of which 15 to 16 lakhs. What were the other mode of payment received by you from Satyanarayan Judge? I stated I would go through my bank statement and further state that I might have received the cash from the Satyanarayan Judge. I would submit the bank statement within a day or two. What did you do with this amount received from Sri Satyanarayan Judge? I have made payments to various other people during the course of my business as a participant in auctioning during the purchase of Mrs. Gaikwad Mills. Do you agree to the fact that the amount of money received from Mr. Jaju was to the process of trust? As I have noticed that I have received payment from Satyanarayan from Sri Jaju, who in turn received from Mr. Sai Prasad Organizers Private Limited Surat. The same company and others were charge sheeted by CBI. I also state that the receiving the amount was a crime, and after having studied section 3, this is what has been there to him, but even he did not know about how the money came. So he admits that as a right deal against he received 15 to 16 lakhs from me.
Where is that land deal?
So that's not mentioned anywhere in the charge sheet.
No, you made a submission, so the amount was towards that land purchase dealing.
So the money was transferred against the land deed. I was saying this, if you transfer, I transfer.
Yes,
So I was one of the broker. Now, kindly see, I have given an application. On 19/3/2022, before this on the company handed an application on
Hmm. Yes,
where I have produced the photocopies of the 3 checks which was issued by accused number 1, which were dishonored. That was for the 3 checks worth rupees 11 lakhs.
Hmm.
So out of 30 lakhs, this was also shown to the investigating officer, but they did not record, they did not make it part of the statement.
Hmm.
This copy was also given to the prosecution, no reply to this. Now kindly see, so therefore, my answer to this the case is that if I go by prosecution case, I'll take the reply, madam. Not see, first the reply, then I'll make this, show the account and everything. Kindly see the reply.
yes, yes, yes.
So page 7, this is the history they are reproduced, all the details of the
Reply
schedule
also.
offense. The reply was filed on 26/6/2018.
Hmm.
Now, up to page 7, it is a reproduction of the schedule offense. Can you see page 8? Here the table is given where is the entry of 30 that is received by me, that's what they say. Then can you see the para 17? Very. Parameter.
Hmm.
That's with respect to myself.
Yes.
Yes. Further, during the course of investigation, statement of the Sojitra and Jaju was recorded in section 50 of PMLA 21/11/2014, wherein the interior stated that he is an account with so Bank of Baroda, so and received 5 lakhs and 5 lakhs, 15 lakhs and 10 lakhs on 13th and 15/10/2009 respectively from session. Mr. Sai Prasad organizers prohibited to RTGS transfer. That is, the sale amount was for the land deal that was struck between Dinesh Jalpara, director of Mr. Sai Prasad organizers, and Sri Vikram Choksi. That on the directions of Mr. Dinesh Jalpara, he had transferred an amount of 5 lakhs to Vikram Choksi and so and so, that he invested 10 lakhs on so and so so and so. Further, it is submitted that the applicant in his statement stated that dated 21/11/2014 has stated that he has paid 15 to 17 lakhs, including 5 lakhs. In fact, the scrutiny of the bank account statement of the applicant reveals that the applicant had instead of transferred an amount of 8.50 and not 5 lakhs. Now then further they have given us the accounts of 5 lakhs to the and 50. Ultimately, this what they say 15 to 16 lakh rupees apna, that is become has also confirmed. Further, more of the applicant in his statement dated 21/11/2014 has stated that out of the amount received from accused number 1, he has invested 10 lakhs for purchase of the shares of Ronta Rising Stocks Private Limited. So these 10 lakhs were the use of my money, which I was to receive 11.5 lakhs from. So out of this my money, I invested in Rising. Reveal that he had actually invested 14 lakh in the said stock, so that is the dates have been given about the investment, how it is made with the Rising. So it is not that the money which is the profits of that, it's my own money I invested there. Now can you see further? The investment made by the applicant in Ronta Rising Stocks is confirmed by the director of the Ronta in his statement dated 1/6/2018 recorded in the section 50, wherein he intelligently stated that applicant holds account number so and so with since 4/8/2009 is a prior to the account. So this has nothing to do with the present offense. But if I had only as per the instruction in my account would have been subsequent to receipt of the money. This is from prior to this, the account. For there's a trading of the shares and that is the applicant has invested 14 lakhs with them during 14/10 to 16/10. This pertinent to mention that government of the applicant, that is the main perpetrators of the fraud in this Jalpara, had given him the amount of 30 lakhs to RTGS of the Bank of Baroda, and the applicant had mentioned in his statement dated 21/11/2014 that Dinesh Jalpara had transferred the said amount for a line deal struck between him and one Mr. Vikram Choksi of Badoli, which is the direction that the applicant should transfer this amount from his account. The applicant has affirmed in statement that out of his RTGS of 30 lakhs, this applicant has transferred 5 lakhs and so and the balance amount 25 lakhs was utilized as lender. Now kindly 10 lakhs invested in Ronta, 12 lakhs given to the Vikram Choksi, and 343,613 is the balance. However, the investment reveals that the present applicant has in fact transferred 8.50 to Vikram Choksi. Invested with this company and the balance amount. So if I make the is the statement 850, 14 plus balance, and it will not match this of figure what they say. Then can you see further? The para 24 then statement. And 23 also. From the above, it is revealed that the applicant had knowingly played a vital role. Now, knowingly how knowledge? That is not mentioned either in the complaint or the reply. I did transaction, I transferred, yes. But where is in the complaint stated that I had a knowledge? But big point question was put to me, I said, no, I did not have a knowledge. Even they are unable to show from the complaint or from the reply that how I had a knowledge about the schedule offense. This false statement has been made, knowingly played a vital role in layering and integrating the tainted money as he received a huge amount of 30 lakhs in his account without any logical, legal and verifiable business transaction. Now here they say, Vikram Choksi confirms yes, there was a lending. But if either the Dinesh Jagpara said, so either statement is to be discarded wholly or it to be accepted as it is. At this stage, it has to be seen as it is. Then Vikram Choksi confirms, yes, there was a lending and I received. It is their own case. In fact, in the complaint itself, now they are saying something different here in the reply. It is evident from this act that the applicant and accused number one were well known to each other and hence he knowingly indulged. Now, knowing does not make the knowledge. I should have knowledge about the crime, not the person. So that is nothing to show that I had a knowledge about the crime committed by accused number one and that 30 lakhs which has come to my account was a process of crime. Then paragraph 24. Accordingly, it is construed as the applicant is misleading this honorable court and is trying to camouflage his role of knowing and willingly of purchasing, acquiring the process of crime amounting to 30 lakhs from the accused number one, who is the friend of the applicant. This goes on the proof as the applicant and the accused number one were known to each other and therefore the applicant has knowingly helped the accused number one in camouflaging the process of crime by allowing him to route the safe tainted money through the accounts of his applicant and thereby projecting it to be legitimate. Therefore, the applicant has knowingly and willingly indulged himself in the act of money laundering as designated by accused number one, and also he has retained as a part of the process of crime, that is 19,85,000. So they have deducted the 11 lakhs which was towards me, my amount. What I was saying was a 3 check which I was saying showed this honorable court. Then there's a provisions of law has been mentioned. Again, para 26, my lord. They say para B. The applicant knowingly and widely acquired, retained and invested a part of the process of crime amounting to 19.85 lakhs. So what does the check I produced before this honorable court? By way of an application. In the reply, they accepted it. Out of 19 lakhs, 16 lakhs I have transferred. Balance is seized by this honorable court. Now let's assume that also I received amount. I transferred 16 lakhs. Balance was in my account. But where is this any whisper about the fact that I had a knowledge or not before the going to the questions of law and so we out table में पहला earlier time आपने लोग आपको calculation is there in the record. Only one of the things. Similar and supply. Because the entire summary was prepared and given. Because I came to know about the time when CBI called me, not before that. Because at the time of hearing, I passed over to one of those.
Yes.
I will make available one more. So therefore, I received rupees 30 lakhs from to the bank account. Now I'm not an accused in the schedule of offence, there is no allegation against me. In ECI, I was not an accused. Now to make me an accused, there has to be some government, some evidence to allege that I had a knowledge. Mere making allegation that I had a knowledge is not sufficient. Therefore, what they say, so for account, the 11.50 lakhs I received against my money, 16 lakhs I had given to the Vikram Choksi, 5 lakhs has been returned to the SBI under the instruction that is also not placed on record, my lord. It would be perhaps the part of the unreliable document because one of the letter which is given today in the list that it requires SBI's communication. But the document has been not been provided. Probably it will be the same document for return of 5 lakh rupees to the State Bank of India. So then nothing remains with me. 16 lakhs is transferred to the Vikram Choksi. 5 lakhs you return to the bank. Then out of 30 lakhs, the 11 lakhs if I have to take out my money, then nothing remains. On the point that total comes 11.50, 16 lakhs and 5 lakhs, 32.50. And I received 30 lakhs against that. So I am not in possession of the procedure of crime. Because 5 lakhs returned to the SBI and 16 lakhs given to the Vikram Choksi and 11 lakhs is towards my own money. For that, I have produced on record that the copies of the bounce check and the return memo issued by the accused number 1 company. And that was shown to the investigation officer, not taken on record. It was produced before this honorable court, and then they accepted in reply that the process of crime is not 30 lakhs, it's 19.85. Even from the bank accounts, my lord, there's one of the entries I can show. What you may see is a bank account. Page 78. Page 78. The entry, the second last entry.
No. So you received in total 30 lakhs from A1.
Not 30 lakhs.
Then?
19.85 as per the reply.
But
And which tallies with my calculation that I want to receive 11 lakhs of mine, which I invested with this Runta in the share markets.
in your statement, you stated you accepted 30 lakhs.
No,
You received.
Amount.
You received 30 lakhs. You received 30 lakhs.
Yes.
Then out of 30 lakhs, you have given
Process of crime as per the prosecution in
out
the
of
reply,
30 lakhs, you have 5 lakhs returned to the
SBI.
for what reason?
The SBI returned it, this money was the bank you returned, I have returned it.
Money was of the bank.
Bank, SBI,
Now, why would bank give you 5 lakhs rupees?
because the money was transferred to my account, it was, the account was showing. At least that's what I'm showing from my account itself.
Okay, so that was a different amount, but you
So the
received
same amount, what I received, that 30 lakh
you
rupees.
received 30 lakhs in total.
મારા કાપી લીધા તો બચે છે 1950 અથવા 1850 બચે. During the investigation of the CBI, bank asked me to return because I said that 1150 મારા છે 16-17 લાખ રૂપિયા મેં વિક્રમ સુખ્યા તો 5 લાખ બચે ને તમારી પાસે તો પાછા I returned it 5 lakh rupees to SBI.
At the time when
Investigation of the CBI.
but till that time you did not came to know that this 5 lakh rupees have come into your account for no reason.
No, I was aware of 30 lakhs. But this amount was coming after committing crime, I received that I did not.
No, that is a different thing.
Yes,
But in total you received 30 lakhs.
30 lakhs, yes.
5 lakh you return back only at the time when CBI came to you and you asked him.
And SBI said that this money which is lying with you is the client money you return to us, she may ask me to return, I return it.
But it was from the account of the A1.
No, I received from account of A1, but I received from my account to directly the SBI.
With that. Okay. And you paid how much amount to the A6?
To
How much amount you paid to accused number 6?
accused number 5,
5 with who, with
16
whom?
to 17 lakhs, 16 lakhs, cosmetic the lower figure,
16 lakh.
16 lakhs.
So
5 lakhs I returned to the bank.
out of 30 lakh, you paid 16 lakh
That is what becomes of statement I read over to one number 4.
to A6. He is A6.
A5,
A5.
sorry, not A5, I am the
Hmm.
A6. Yes, A6.
Hmm.
I am A5.
So 16 and 5, 21 lakhs.
Yes,
And 9 lakhs rupees.
I'm fine.
So 9 lakh remains with you.
16 lakhs I given to 5 lakhs to the SBI.
Hmm.
And balance is mine. So I was to receive 11 lakhs.
Hmm.
With interest 1150, I landed 11 lakhs. And I have to receive back plus 1150. And for which the checks were issued. Just hand it on the application. I have annexed a copy. I just showed you all about it. I will see that application of 19/3/2022.
Later. You are at discharge stage.
Okay.
You are at discharge stage.
Yeah,
So
but
why-
this is the undisputed inimpeachable document.
But,
These are the banking transactions.
but why we should?
Investigation officer did not record something in favor of the accused, they don't record it. These are the banks transfer checks are the issued by the accused number 1.
But that can't be looked into at this
But they
stage.
can't speak and choose. I stated to them, they don't record it, then what is the remedy for me? I cannot be left remediless.
You are with remedy. You are not without
You
remedy.
see, these are unimpeachable documents. I have placed it on record. They are not denied it. There is no reply to this application. It is now 3 years has passed.
Let it be.
This because these are the checks. That's what I'm saying. This money which I received, part of 30 lakhs, 11 lakhs was my own money, which I have received it back. Because the checks of 4th August 2009 and 5th August 2009 were
Even if you
bounced.
go to believe your say on the basis of those documents,
Yes. Now
Yet-
when I see the account statements,
now then what was that money you received from? The checks are returned back.
these checks were returned, was issued by this accused number 1.
Accused number 1 gave you 3 checks.
Sorry?
Three checks.
Yes, 3 checks.
And all those checks are returned.
All returned.
And that 3 checks
Then
are.
we received the RTGS transfer of 30 lakhs. By saying that there's a you deduct 11 lakhs of your amount, transfer 15 to 16 lakhs to Vikram Chopsy, keep balance, and give the instructions.
Now what is that amount of 3 checks?
Yes, it was 5 lakhs, 1.5 lakh, and 5 lakh, 11.50. The record for how will you have the The still original checks are with me, my lord, please.
એ તો એમને રજૂ કર્યા છે ને.
I
હા, એ તો
can
ઘણી
give,
છે.
it's not on record, the application, I give another photocopy.
So your say is that these 3 checks were given to you which are dishonored.
These 3 checks were earlier transaction, I lended him money of 11 lakhs, which was what to be returned by these 3 checks, which was bounced.
This check got dishonored and
Dishonored.
therefore, okay, and therefore he made RTGS payment to you.
Of 30 lakhs rupees.
Now why he would give you 30 lakhs against 11.5
Yes,
lakh.
so 11 lakhs was to be created against my money and balance was further lending. Out of that, I was given instruction to transfer 16 lakhs, I transferred 16 lakhs.
Hmm.
Because I was a broker, I was holding money.
As a broker, why would you lend money to the accused number 1?
No, it was a personal transaction with different because it is not unknown that I did not know him. Since I was knowing him, then only he trusted me. Otherwise, there was no reason to trust me. There was the earlier transaction, I lended him 11 lakh rupees
Hmm.
to the company, which was to be returned. That was these 3 checks were issued.
Yes.
Now kindly see the page 78, this is my statement they have produced on record.
Hmm.
Bank statement.
Yes.
Mine says that in May I transferred 2 lakh rupees to them by cash. My case, how does 11 lakh, I'm given account of 11 lakh. How I given to accused number 1. So, and rest I this by the check. Possible point. The 22nd,
July.
22/7, this entry of 5 lakh rupees transfer. And then entry of 30th of July 2009, transfer of 4 lakhs. So 5 lakhs and 4 lakhs by transfer,
Page number
78.
78. It is not, sir. It is Bank of Baroda.
Bank of Baroda. The statement starts from page 70, the statement starts from page 75. And the name of the minor on page 76 top. Bank of Baroda, account name Satyanarayan Discharge. Am I with the number 4?
I am on page number 78.
78 now. Kindly see in the bottom, with the entry of 22/7/2009, transfer of 5 lakh rupees,
Hmm.
which was given to the accused, and the instruction to the accused number 1, 2/1, and this is have a reference in the provisional attachment order on page number 35. So that is provisional attachment order has not been produced here. But then I can produce that provisional attachment order, but that's a reference in the provisional attachment order of this entry and the second entry of 30th July 2009 of 4 lakh rupees. This 9 lakh plus 2 lakh rupees was given in cash, against which these 3 checks for 11.50 was issued.
Hmm.
Which was dishonored, and therefore. So then as a page 8080 kindly see. The 30 lakhs how I received.
Yes.
Kindly see. Page 8, am I on number 4 page 8? Now kindly see there are other 3 entries of the entry of 13th October RTGS, what is SBI. Here October money entry just said 5 lakh rupees.
Hmm.
Then
Yes.
second is a 15 lakh rupees entry, it's a 15, that is also RTGS SBA. And third is of the 10 lakhs, maybe 15 10 entry. Then my lord will find the name of the company also signed process.
Yes.
This is how 30 lakhs I received. against which is the disbursement of 18 lakhs to Vikram Choksi. Now kindly see. This first is a 1510, 2 lakhs rupees transfer. Withdraw the columns at left hand side of close. 15 lakh की ऊपर नहीं entry से काम होता है. 1.5 lakh, then 5 lakhs rupees. Vikram Choksi, my lord, you will find the name also. Then 1 lakh on the same day. Then on 20th October again 1.5 lakhs. And then 26th October 2 lakhs rupees. Total 16 lakhs.
Hmm. Yes,
And cash I transferred Vikram Choksi of 5.50. The total 16 lakhs I given to Vikram Choksi.
yes,
And page 82. The amount attached. 343,613. The balance in my account.
hmm,
As of 2014. Now therefore kindly see. Now these are the factual aspects, my lord.
hmm,
Now kindly see section 3, my lord.
now. PMLA. Yes, you can read. You can read.
I was subsequently added to that, I want to show that. What was the section that they learned in 2009?
Yes,
So there was amendment in 2013, my lord. By when the sections were amended. May I read? Whoever directly or indirectly attempts to indulge or knowingly assists or knowing, so knowledge is must. Knowingly assist or knowingly is the party or is actually involved in any process or activity connected with, then it is in 2013 amendment. I'll skip that amendment, my lord. Probably there would have been marked down in the book also, my lord. This portion what now I am reading is amended in 2013. Process of plan including its concealment, possession, acquisition, or use and projecting that has been amended in 2013. So for purpose of these matter it cannot be ready. Because either in 2009 this was not an offense. This portion, what in concealment, possession, acquisition, or use and projecting or claiming it was not an offense in 2009. These are the transactions of 2009. This will be added on 15 February 2013. So if I take out this amendment, then possession, acquisition or use would not be an offense under section 3.
yes,
So if this is the fact, then one has to see the knowledge. If I read again, who, if I read it without this amendment, then section would be like, whoever directly or indirectly attempts to indulge or knowingly assists or knowingly is a party or is actually involved in any process or activity connected with it as untainted property shall be guilty of this offense of knowing or not. So then knowledge is a sine qua non.
Yes.
Therefore, if I read this section, document just turn to ground B of my discharge application where I have. After how is the definition I have break into the that's I have given try to just explain in ground. F the section 3, what are the requirement? Acquisition of process of crime, indulge in process of crime knowingly and claiming is untainted. These were at these days in 2009. And derive, distribute and disguise. These are the three elements is required to prove. Now, based on that, now can you come to the next page? The ground D. Probably is corrected and ground F. That is the definition of process of crime. That's the line start with. So printed on ground D inevitably it should have been ground F. May read that if the definition of process of crime and section 3 are read together. Am I on report?
Yes, yes. What you
What is
do?
the- Then it is crystal clear that the offense is committed when it is claimed that the impugned property is derived from tainted money. There is nothing on record to show that the applicant is actively involved and had dealt with the process of crime knowingly. In other words, there is no evidence on record to show that the applicant had knowledge that is the money arranged for purchase of the property in auction were obtained by criminal activity. Then the conclusion which I draw. If applicant cannot be deemed to have mens rea in the absence of registration personal liability on the date of the elite offense, the applicant is not in possession of a process of crime which can be attributed to a scheduled offense. In absence of mens rea and process of crime, which are prima facie evident, there can be a cause of there cannot be any cause for invoking section 3 and for the above reason is here and privilege to be discharged. So these are the crux of this section. Now there are 3 judgments on this issue. Because section 2(1)(p) also attributes that the knowledge is important. Then what you may see this in ground O, I have quoted the relevant paragraph of the Honorable Supreme Court in the matter of Nikesh Tarachan. By the para 7.
Which Nikesh Tarachan? Not
No,
not necessary.
in other in mind the application I have quoted it. May I read Maladan?
Why you want to read?
In ground O,
Yes.
in
read.
para 7, an important ingredient of the offense is that the person must be knowingly or active. The word used Supreme Court is must. Knowing or actively involved in any process or activity connected with the process of crime. And then our High Court in 2 different decisions. that I have put it in the Jafar Mohammed Hassan Patta. And that Jafar Mohammed Hassan Patta has been followed in another decision by the coordinate bench. These are the three decisions that the Jafar Mohammed Hassan Patta has been followed in the matter of Santosh Naik. Again, both is the decision of our High Court, SLP has been preferred, but no state till today. So that those accused has been still stand as a discharge into the PMLA offences. That's matters of the approach Patta group. And both of the judgment deals only on the questions of knowledge. Because there is one of the relatives or the directors of that company. One of those Jyoti Pal is which has recently been argued before his honorable court. That is the contention was the two court contentions. All the three directors has been discharged by High Court. And second contention that the management of that company has been now taken over by another company. 32A of the IBC has been argued by us, my lord, before his honorable court, and that application for discharge is pending. So those orders, and these are not connected with this matter, but on the questions of knowledge, both these our High Court judgments hold that the knowledge is a sine qua non. If there is no knowledge, one cannot be attributed or one cannot be tried for the offense of criminal law. Because if there is no knowledge, and one cannot impose a mens rea. Criminology requires a mens rea. So if we read section 9 as the then was, section 3 the then was in 2009 period, then it will have the knowledge is must. The section then amended in 2013.
Okay.
Then one more decision on the knowledge. Supreme Court, while interpreting the questions, and passing on those three judgments as well as the Supreme Court. And you see it is 2022 SCC online. SC 1164.
Okay, check. It is here. It is here.
Yes, see Kumar.
See,
Yeah.
happy to pass you. Oh,
Now kindly see this effect. That the case was that there was a murder and there was a theft. The petitioner before the Supreme Court was not charged for the murder but was charged for the theft. Now let me see what is the effects. Para 5, my lord. In the common judgment is the High Court has disposed of the three appeals, including this appeal filed by one Sandhu Singh alias Vijay Ban Singh Patel, who was convicted for murder and other offences and was sentenced inter alia to imprisonment for life. The appellant and one Satrughan Prasad were not charged in the murder case but were charged with the offence of receiving stolen property and were convicted for this offence punishable in section 411 of IPC. Then last 4 lines of the para 6, my lord. The line starts with this loaded goods in the truck were looted, my lord. Looted, and those stolen articles were dishonestly received by the present appellant Shiv Kumar and co-accused Satrughan Prasad allegedly knowing. Now this is what the knowingly has been interpreted by the Supreme Court as far as showing. Allegedly knowing the articles to be stolen property. It is the further case of the prosecution that the goods in question were sold at cheaper rate by the two accused who were accordingly charged for the offence under section 411 of IPC. Then I'll straightway take the honorable court.
that was after conclusion of the trial.
Yeah, but ultimately, what is interpreted as para, can you see 23, 24 and 25?
That will, after evidence is recorded.
This knowledge is important.
Knowledge. That judgment knowledge was ascertained after the evidence, there was no knowledge.
Can you see what the Supreme Court says?
Yes,
It's very paragraph.
but that is said after recording of evidence. In your case,
Yes, but ultimately the principle will apply the same.
yes, it will apply
Today,
the same.
what I'm saying, after evidence, yes. Today, what is honorable court has to see the charge sheet papers as it is.
So knowledge while asserting at the stage of discharge would be different than ascertaining knowledge after evidence has come on
There has to
record.
be something to
There-
show that I have knowledge.
There can be common criteria for it. Knowledge means this, and this. So
That is
for
the-
every occasion, there can be, no, you satisfy me, I don't.
So I am saying this even.
Ah,
if
knowledge
the
is say okay.
documents are taken,
Knowledge is okay,
on knowledge only actually.
but that is this judgment, how it would be applied?
No, it's applicable on the ground.
Because we can't go, the judgment of Supreme Court is to be relied on the basis of principle, not on factual aspect.
That's what I'm saying.
Ah.
What was the factual? That's why I read facts first before the honorable.
The fact says that it was,
It was a stolen.
that they were not charged for murder.
Solve any વસ્તુ જો કોઈ 50 રૂપિયામાં વેચતો
By,
હોય તો
in
bound
simple
to be-
in simple એટલું કહી શકાય કે 411 નો કેસ હતો, મર્ડર નો નહોતો એવું.
No, I'm not.
પણ અહીંયા
Stolen property, what is the prosecution case was that?
You
That is
point-
in prosecution
you
case.
point out the proposition of law by Supreme Court, that I will consider.
One word.
But that is after the,
Yeah, I think knowledge is much.
yes,
Obviously, first para 11 and then I'll go back to this paragraph. Because what was the contention of this state? Can you see first?
see, this is after, I am not going to consider it.
May not, my duty to ask is honorable.
No, I am telling you, therefore I am putting you to your knowledge, that this won't be applicable straight away. Yes, so,
Well, it is, yes, that's what I'm saying. Yes, it is after full-fledged trial. But I'm saying as, even if the charge sheet papers are taken as it is, as if the trial is over, then also there is no material to show that. See, there's only a difference between pre-charge, pre-charge.
you
and
can
after,
certainly point out the
evidence.
proposition with regard to your contention about knowledge, but only proposition.
That's what I'm saying.
I won't be going into the facts of the other case, that why this Supreme Court has come to the conclusion that there was no knowledge, because there was evidence after conclusion of the trial.
I'm saying let's the charge sheet papers as it is being taken. as
That,
the evidence
that
is over.
contention is okay, that's fine.
So
That I have knowledge, that there was no knowledge,
Yeah, therefore now can you see three paragraph of 23, 24 and 25.
yes.
In Timbak versus State of Madhya Pradesh, this court discusses the essential ingredients for conviction in the section 411 of IPC. Justice so-and-so, in his opinion, rightly observed that in order to bring home the guilt in the section 411 IPC, the prosecution must prove that as the stolen property was in possession of the accused, that some person other than the accused had possession of the property before the accused was possession of it. And that, now when the third part is important, and that is the accused had knowledge that is the property was the stolen property. So here prima facie the prosecution has to show that the money 30 lakhs was transferred to my account. I had a knowledge that it is a crime money. That is how I am correlating two facts, and then I am taking section 3 if read and section 4 and 11. Both sections require the knowledge. So if we break these sections and the fact to fact we this, then this is a kind of similar comparable is possible. That's what I'm saying. Now can I see further? When we apply the legal proposition as propounded to the present circumstances, the inevitable conclusion is that the prosecution has failed to establish that the appellant had knowledge that the article seized from his possession are stolen goods. These essential elements was not established against the appellant to bring home the charge in the section 411 of IPC against him. That apart is the disclosure statement of the one accused cannot be accepted as a proof of the appellant having knowledge of the utensils being stolen goods. The prosecution has also failed to establish any basis for the appellant to believe that the utensils seized from him were stolen articles. The factor of selling utensils at a lower price cannot
Okay,
by
yes,
itself
okay.
lead to the.
Chalo, yes. That is, prosecution has failed to establish, that
Here,
was after.
there is no evidence produced along with the charge sheet papers
Okay.
to show that I had a knowledge. I would say the prosecution has failed to produce even but to frame a charge.
That's
To
what.
frame a charge, is some in Pepsi Food bylaw is aware. The Supreme Court said,
Now it's 2 and 10.
no, we have to mark it.
हाँ बाकी छे.
So,
मतलब
Pepsi Food
Next.
Supreme Court made, and I'm concluding. I'm not no problem. In Pepsi Food, Supreme Court did say to take the cognizance of the criminal offense and to put someone into the trial is a very serious thing and it should not be taken lightly or routinely. Application of mind has to be there. The filing of the private complaint or filing of the charge sheet has to be equated. There also cognizance to be taken, here also cognizance to be taken on filing of the charge sheet. So filing of the charge sheet, court has taken cognizance. Where here this is the Pepsi case and this is the PMLA case has to be on the same footing. There also private complaint, here also private complaint. So if there is nothing in this a private complaint to show that even prima facie or other is a document produced which would impute knowledge on me.
so anyway, yes, you can continue.
Mere allegation.
PepsiCo case, that is a complaint case. PML is also a complaint case.
Not complaint.
That itself would not be a ground. There would be same set of,
No, sir.
Huh.
Kindly appreciate the revision to the judgments has come.
Yeah,
Because amendment.
but that would be a different. We are not on that aspect.
No, why I'm saying apply.
Yes, it is a private complaint. But under which enactment?
But it will have, that's
And
why I'm answering to my words.
And this
That's
is,
what I'm answering. In BNSS, the comparative provision section 200 is up to 23. There is an amendment. in-
we are not with BNS
No,
or
it will
BMS.
apply. Section 200 will only apply. That's the judgment of the Punjab and
It will
Haryana
apply.
High Court. Okay,
Okay.
even if now as per the BNS, there's a.
Anyway, I drop my query.
And let me complete that.
Now you conclude your argument
Yes,
on
sir.
this.
BNS section 223 is proposing that before taking cognizance, accused has to be heard. So that for any private complaint, the accused has to be heard. Punjab and Haryana High Court has held that, and Delhi High Court, even in PMLA being a private complaint, same provisions will apply to students because there is no separate provisions in PMLA to take cognizance. So that before issue taking a cognizance, accused has to be heard, and the order of cognizance has been fought by this Punjab and Haryana High Court on that very ground. And as the Delhi, there are two judgments on this very issue on PMLA. If required, I'll supply those judgments now. So what I'm trying to say is the proposition because section 65.
Why are you
section
till
71
High
of
Court
PMLA.
only?
I'm not coming to PMLA.
No, why are you till High Court only? There are now decision of the apex court also with regard to
I haven't
government.
come across yet.
Anyway, yes.
But on PMLA, I have come across with the High Court judgments. On this taking cognizance because now it is amendment provision. Accused has to be heard. So even in PMLA, accused has to be heard before the issues of there are procedural laws. So I'm not going to that stage. I have to have been heard because the procedural law applies retrospectively. What I'm saying here that knowledge has to be there. It has to be inferred from some document. One cannot be put to trial just making mild allegation that he had a knowledge. But I have to show something from the paper produced or some other mean how I had a knowledge. There has to be something on record as a part of the complaint because there is no amendment is allowed in this complaint. It could be supplementary complaint for this another accused, not even for this the same complaint. So, but there is a difference in supplementary charge sheet and supplementary complaint. There is no amendment permissible either in the CRPC or in the PMLA. There is no provision for amendment.
It is not there.
If there is no amendment permissible, then we'll have to see complaint as it is. And its amendments as it is. If there is no amendment in the complaint, how I had a knowledge. If that is the absence, then knowledge cannot be inferred by merely saying that I had a knowledge.
That contains another report.
That what this case is not made out against me, and I'm requested to discharge. Please.
Report, please continue.
By the apex court reason, in the judgment of Pradeep Sharma. The application 655 of 2024. And in the relevant contract, thereby court has specifically stated that offense of they will continue to perform. And so long as the person holds the piece of crime, the act as on date should be applicable. And offense being a continuing offense, it cannot be the retrospective effect of the PMLA was discussed and the ethics code does observe that. While why is it different? Similarly, it was also consideration for that offense dates back to before it was being nominated as notified as a scheduled event. So if it was in paragraph 21. That would be 6.8.
Yeah.
Paragraph 21.
Hmm.
A significant long raised by the applicant present pertains to the nature of alleged offence under PMLA. The applicant has contended that the alleged act do not constitute an offence under PMLA as the same was not in force during the relevant period or the predicate offence as alleged were not included in the scheduled offence. It is also has been urged that the instances do not constitute the continuing offence. This contention, however, is untenable. It is well established that the offences under the PMLA are of a continuing nature and the act of money laundering do not conclude with a single instance but extend so long as the proceeds of crime are concealed, used, projected as untainted property. So in the present case, accused is holding the possession of the proceeds of crime and till date he has been in the possession. And it will not be the case that the act as of 2009 would be applicable. So since it is a continuing offence, Apex would have clarified that position that PMLA as of date would be applicable and not the retrospective offence. Secondly, the paragraph 20. The concept of continuing offence under PMLA has been well established by the judicial. Continuing when the illicit act or its consequences persist over time, thereby extending the liability of the offender. Section 3 of PMLA defines the offence of money laundering to include direct or indirect attempts to indulge in knowingly assist or knowingly be a party or actually involved in any process or activity connected with the proceedings of crime. Such involvement is prolonged, constitutes the continuing offence. In paragraph 20, the Apex code also finds the line deduction. Paragraph 23. Apex code has also referred to the citation of Vijay policy, whereby the ambit of section 3 was discussed. So, as per section paragraph 20, even though the issue of retrospective application of PMLA is pending adjudication before this court, the reference by the respondent on the observation of the court in Vijay policy cannot be said to be misplaced. This court, in its judgment in this case, made the following observation. From the bare language of section 3 of the, it is amply clear that the offence of money laundering is an independent offence regarding the process of activity connected with the streets of crime, which had been derived or obtained as a result of criminal activity relating to or in relation to a scheduled offence. The process of activity can be in any form, be it of concealment, possession, acquisition, use of proceeds of crime, as much as projecting it as untainted property or claiming it to be so. So the as the council has bifurcated that section 3 would be applicable to a limited extent as of 2009, that aspect has been clarified in the judgment, and it is it is relevant because this is also with respect to PMLA. So ambit of section 3 has been discussed. So far as the role of the present use is concerned, so far as the role of present, he has been in possession of he has received of various branches. Firstly, he has received rupees 5 lakhs on 13th of October 2009. Thereafter, 15 lakhs and 10 lakhs on 15th of October. From the account of 5 Prasad organizers, and transfer an amount of rupees 5 lakhs from his bank account to the account of the Vikram Chokshi. He had in all transferred 15 to 16 lakhs to the account of Vikram Chokshi. He had also invested some of the amount in Runta Ice Cream Limited on 16th of October. So far as his statement is concerned, his statement at page number 83. Question number 3.
Yes.
Question number 3. On seeing the statement of your bank account, it is noted that you have received 5 lakh, 15 lakh, and 10 lakh on 13th October, 15th October, and for what amount? Not the permit option. I'll keep page number. You have also read that statement.
Page 83 now.
Yes. You have read.
Applicant statement.
Okay, I'm sorry, I missed out.
I state that as a private organizer, private limited, from their own account, for their account with SBI, Sojitra branch, Surat, had made RTGS transfer of the said amount in my account with the Bank of Baroda. Dinesh of Mr. Sai Prasad had transferred the said amount for the land deal that struck between him and one Mr. Vikram Chokshi of Bardoli, with the direction that I should further transfer the amount from my account. Accordingly, I have transferred 5 lakh to Vikram and 15 on. I have transferred 5 lakh to Shri Vikram. In all, I have made payment amounting of 15 to 70 lakh to Shri Vikram on the directions of Dinesh Jalalsra. So this shows that he was working on the directions and he was working in connivance with accused number 1. And he was in knowledge that so and so amount has been received is nothing but the proceeds of crime. Who had entered in the land and I got the brokerage, and I also paid that 10 lakh was invested with Runta Rising on 15th of October, for which I would submit further details. Next question is, sir, which shows the contradiction of the two answers. Question number 4 at page 84 is again relevant. Question 4. Do you know the Dinesh Jalalsra had ticket SBI for which he was charged sheeted by CBI Mumbai? Here's the answer is important. I state that CBI Mumbai had also made me a witness in the charges, as I have unknowingly received 30 lakhs. At one stage, he has said that I have received as a brokerage, and in there he said that I have unknowingly received the amount. So there is contradiction in statement, and he has also stated that I was working on the other part is relevant. That I have been working on the directions of Dinesh Jalalsra, which shows that he was in connivance and having the knowledge that such and such criminal activity is being committed. Then his account transactions are also important. Based on the statements which are relevant and the discrepancy which has come on board. Page number 2, sir, I'll just point out. The third point, the discrepancy in the statement. In this statement, Shri Jaju stated that he paid rupees 15 to 17 lakhs, including 5 lakh transfer to his proxy. But on the bank review, it has come through the scrutiny of the bank account. It was found that Shri Jaju has transferred 8.5 lakh instead of the claimed amount of rupees 5 lakh. Then the statement, in his statement of 21 of November, he claimed that in his investment, he had invested 10 lakhs from the account amount received from accused number 1 for the purchase of shares in Runta Rising Stock Private Limited. But the bank's scrutiny shows that it was found that he had actually invested 14 lakhs in the shares instead of 10 lakhs. The deficiency also sees, which was that there is so he is not offering any explanation as to how and why the people of crime was seen and how it was taken into account and for what purpose. The purpose he has stated is contradicting in his own statement. Then the statement of Vikram Chokshi is also relevant at page number 85, whereby he stated that he has only received the proceeds of crime from accused number 5, which also specifies, which also clarifies the position that everything was being done in private and everyone was holding the knowledge as to what active financial activity was being done. And just under the garb of that, he was working as a broker. Under the garb of brokerage, this was nothing but a transaction to route and further layer the proceeds of crime from one account to other. Just under the garb of taking it to be a brokerage amount. Then they have also said that he has not been named in a predicate offense. So Vijayamandana Solicitor para 51 has specifically categorized, even though person is not named in the scheduled offense, if he is found to be in possession of proceeds of crime, then in that case he can also be made an accused and his properties can also be attached. Then they also refer to the ECI at page 31, which where his name and not been mentioned, but his name had surfaced from the further investigation, and it was found that he was in the possession of proceeds of crime, which was also attached.
Unreported decision, then you could supply the form.
Yes.
Reported, then I can get it.
And for the permanent. That those are motive judgment.
Reported, then to the citation, that's only my request. You can get it.
Vijayamandana
Vijayamandana, I'm aware, I'm only on public service. I only request whatever is the reported decision, you can give citation. If unreported, then supply form. You give the citation of public service. So there are many benefits to the benefits on the Supreme Court. But I cannot get the software with this name.
Number application.
I can deal with, otherwise it would be adjourned for that purpose.
Sir, I've given one note, I've given make this note on the relevant paragraph of Vijayamandana story that I have to rely on. At page number 1, para 252 that I would like to give. Be it noted that the definition clause includes any property derived or obtained indirectly as well. This would include property derived or obtained from the sale of proceeds or in a given case in lieu of or in exchange of the property which can be directly derived or obtained as a result of criminal activity relating to it. So in this case, this is also the sale proceed that they are claiming as it has received as a brokerage, but this is nothing but the proceeds of crime that has been laundered to third person from one account to the other, from one person to other, under the garb of brokerage. Then at bottom 6, 7 line, I've highlighted the rest. Additionally, some other property is purchased or derived from the proceeds of crime. Even such subsequently acquired property must be regarded as a tainted property and actionable under that. Or it would become property for which the purpose of taking action under 2002 Act, which is being used in the commission of offence of money laundering. Such purposive interpretation would be necessary to uphold the purposes and objects of the enactment. Then at page number 2, para 270, I am relying upon. The relevant extract is needless to mention that such process of acting can be done only after the property is derived or obtained as a result of criminal activity. It would be an offence of money laundering to indulge in or to assist or be party to any process of activity connected with the proceeds of crime. And such process of activity can be in a given fact and situation, may be a continuing offence irrespective of the date and time of the commission of the scheduled offence. So this would answer the query that section 3 would be applicable as on date of 2009. Then page number 3, para 220 of the Vigilance Law is relevant. Whereby court, the Honorable Jacob Court observes that dealing with the proceeds of crime can be in any form, in process of activity. Thus, even assisting in the process or activity is a part of the crime of money laundering. So this is more likely would be attracted to the fact and circumstances of the present activity under consideration. Then at the bottom of page number 3 of the note, para 457, 5A, section 3 of the Act has a wider range and captures every process and activity, direct or indirect, in dealing with the proceeds of crime, and is not limited to the happening of the final act of integration of the tainted property into corporate economy. The explanation inserted by section 3 is by way of amendment in of 2009. Does not expand the purpose of section 3, but it is only clarificatory in nature. The word "and" receiving the expression projecting or claiming as "or" and being a clarificatory amendment, it would make no difference even if it is introduced by way of finance and all others. Case of I would also case of Odisha is Devendra Party, 2005 1 SPC 568, whereby they report observed that it is well settled that at the stage of taking of charge, the defense of the accused cannot be put forth. The expression hearing the submission of the accused cannot mean opportunity to file material to be granted to the accused and thereby changing the settlement. At the stage of claiming of charge, hearing the submission of the accused has to be confined to the material produced by the accused. So, they have produced one document they were seeking to rely on. So, at the stage of discharge, only the documents which are part of the complaint can be looked into, and further material as would be subject of the charge. So far as the aspect of knowledge is concerned, it is well established from his own statement. And one say he is claiming the amount would be as the brokerage, and another broker is stating it to me that he has no knowledge about the purpose for which the amount has been received by him. So, in this consideration and further statement of Mr. Vikram Joshi, it clarifies the standard. It has been done in silence of one another, and accused was in knowledge that the amount is nothing but crime, and he has diverted and laundered and assisted accused number 1 and other in committing the offence of money laundering. And considering the facts and circumstances at which the charge does not deserve to be allowed, and if the charge application be kindly given and charges be kindly.
judgment as a matter of ethics or a matter of law is not applicable in the facts in the presumption from three aspects. One, Pradeep Sharma himself was an accused in the schedule offense and he was the main accused. Therefore, and he himself indulged allegations against him of indulging himself in corruption and profits of crime. So knowledge was imputed on him by committing the schedule offense by himself. So therefore, the facts of that case is a different and the facts of present case are different. So on facts, this is not applicable, number one. Number two, the Pradeep Sharma, in case of 2010 or prior there to the delegation. The case was applicable to the PMLA retrospectively. Because the PMLA came into force, the sentence was that the schedule offense was committed on X date, and after that date, the PMLA came into the existence. Therefore, the offense which was committed prior to the PMLA came into the existence, can it be considered as a schedule offense? And then the PMLA be tried. I would say retrospectively, PMLA was being under consideration, not the section what I'm saying. So it will not be permitted even in that case. The date on which this PMLA was introduced in 2005 would be the 4th of July 2005, probably the exact date if I don't make a mistake. What was the date of application?
The offenses were prior to very enactment of the PMLA.
It's different there in that case, and question is different here. Here I'm not saying on the retrospectivity. It's not my submission. My submission for section 3 is there on the date of this offense. There's a 2009. The section which was applicable was as introduced in the PMLA. Subsequent amendment was in the charging section. These are the charging section. What is the charge? It has to be on the date of this offense. You cannot subsequently amend everything. So therefore, what was the section did on the date of 2009 when the offense was alleged to be committed? That has only been even in whichever the law. It is not said that you should see the in all cases the amended provision has to be seen. So it's never that is not the interpretation of the statutes. So that judgment is not applicable in fact because that deals with the principal accused with an accused in the schedule offense and retrospectivity of the PMLA Act itself, not the provision. So that is not applicable, number one. Second, Vijay Madan Lal judgment does not deal with these aspects what I argue. Vijay Madan Lal does not deal with, it's only the uphold the law. On the contrary, Vijay Madan Lal also says that when there is something not an offense, there has to be a scheduled offense to invoke PMLA. That's para 292 where the Supreme Court is given us the example of the income tax. If somebody has unaccounted money, merely unaccounted money is not an offense. It could be subject to the income tax authority. But unaccounted money does not constitute an offense per se. Therefore, there has to be a scheduled offense to invoke the provisions of PMLA. That is a proposition of law. Here, scheduled offense is there. Again, Dinesh Jalpara. So therefore, what I argue that I should have a knowledge that Dinesh Jalpara has committed an offense. By committing an offense, he has process of crime, and that process of crime is being transferred to me. Now, if that knowledge is in absence, it cannot be involved. The two high court judgments of our high court judgments which I have relied, both are at the stage of discharge only. And that is binding to this wonderful court judgment on the questions of law. Because that judgment says neither been overturned nor has been stayed by the Supreme Court. As on today, the judgment is as is applicable. Because in both the judgment is the only law point. It has been considered and if it has been discharged, that the knowledge is must. Both the judgment of our High Court, I have two judgments issued on that. Both the judgment deals with only and that is on the basis of the BAP the charge sheet paper solely. And those two judgments are with all four courts as of now. And those judgments have not been overruled till today, either directly or impliedly. There is no judgment, otherwise the knowledge is not required. That it is a good dangerous proposition. And it will become a draconian. Because criminal law
Is it?
requires a mens rea. The basic principles of criminal law is a mens rea. There is no mens rea, there is no aim and object. Because if we see this aim and object of the PMLA, obviously what I mean is aim and object. That is very, very clear. Just keep on mentioning. The preamble. Whereas the political declaration and structure from an act to prevent money laundering and to provide for confiscation of property derived from or involved in money laundering and for matters connected therewith or incidental thereto. Whereas the political declaration and global program of action annexed to the resolution as 17/2 was adopted by the General Assembly of the United Nations at its 17th special session on 23rd day of February 1990. And whereas the political declaration adopted by the special session of the United Nations General Assembly on 8 and called for the member state to adopt national money laundering legislations and program, and whereas it's considered necessary to complete the opposite resolutions and declaration. And then this is across interest that specific other is missing here. But there's a specific intention was to curb the arms and ammunition, terrorism, drugs, that was the aim. Therefore, it was never an intention to harass, arrest or prosecute a person who does not have a knowledge. These are not the civil liabilities. These are the criminal actions. And therefore, what is being mens rea and knowledge is required. If both mens rea and knowledge are absent, I cannot be prosecuted for that. But there may be genuine business transactions. One does not know if money flowing is from which source. They would have this accused would have made a payment to the bankers. Can the chairman of the bank be prosecuted for that if the accused has committed a crime and has repaid the loan amount? Can the manager or the chairman of the bank be prosecuted? Answer certainly not. Because they were not party to the crime.
These are constitutional arguments. This would be arguments, constitutional arguments.
And that's what I'm saying. If
So
I
now-
test this argument, see, one has to test this argument by similarly situated other examples. If I have to test this argument, the come what made transaction, one has to be prosecuted. But tomorrow with this money, he goes and buys some tea packets. Then
Correct.
that
He may file a suit and pay the court fees.
can is
Larger, yes.
answer is certainly no. So it is not an application of law in that context.
Okay. So
That's all. So the judgments of our High Court which are relying on the original state ruling and the discharge may only the High Court head, that the knowledge is must. If there is absence of knowledge, No cases made out. Please. And person has been discharged. Come on, please.
આજે અત્યારે ગોવિંદભાઈ એરેસ્ટ થયા એમની સાથે બીજા 4 થી 5 આરોપીઓ છે કે જેમણે એક સિન્ડિકેટ બનાવેલું છે અને ફોલ્સ અને ખોટા દસ્તાવેજો ઉભા કરી ગમે તે માર્ગે ફરિયાદી કે વિક્ટીમને મોકલી પછી ફ્રોડ વેરિફિકેશનના નામે પૈસા પડાવવાનું એવી રીતે ગુનો કરવાની ફરિયાદ થઈ છે. હાલના જે ફરિયાદી છે જેમની શાહ કરીને છે એમને આરોપીઓ વતી ટ્રાયના કોઈ ઓફિસર છે ડિપાર્ટમેન્ટમાંથી ફોન આવે છે એ નામે ફોન જાય છે અને ફોન ગયા પછી પોતે મુંબઈ ક્રાઇમ બ્રાન્ચમાંથી એ વ્યક્તિ બોલે છે અને પોતાના ફરિયાદીના આધાર કાર્ડનો મિસયુઝ થઈને ખોટા બેંક એકાઉન્ટ અને સાથે સાથે બીજા સિમ કાર્ડનો ઉપયોગ થયેલો છે અને એ ખોટા બેંક એકાઉન્ટ અને સિમ કાર્ડના ઉપયોગ થકી ઘણી બધી ફરિયાદો નોંધાયેલી છે એવા કોલ જાય છે. જ્યારે પછી આ કોલ જાય છે ને પછી સાહેબ કોલ ગયા પછી એક સ્કાઇપ નામની જે એપ્લિકેશન છે એનાથી પણ વિડીયો કોલ કરવામાં આવે છે અને એ વિડીયો કોલની અંદર સીબીઆઈ આરબીઆઈ એ ફરિયાદીના નામના ખોટા દસ્તાવેજો બતાવવામાં આવે અને પછી એમના જેટલા એકાઉન્ટ છે એની માહિતી મેળવવામાં આવે અને ફંડ વેરિફિકેશનના નામે એ પૈસા પછી એમની જોડેથી એક્સટ્રેક્ટ કરવામાં આવે છે. પર્ટિક્યુલર ફરિયાદીને કહેવામાં આવે વિક્ટીમને કહેવામાં આવે કે તમે આ એકાઉન્ટની અંદર પૈસા જમા કરાવડાવો અને આવી રીતે સાહેબ આખો એક ફ્રોડ ચાલી રહ્યો છે જે ફિક્ટિશિયસ બધાય જેટલા ડોક્યુમેન્ટ્સ બનેલા હોય એ પણ ફિક્ટિશિયસ હોય કોઈ મુંબઈ ક્રાઇમ બ્રાન્ચના કોઈ ઓફિસર પણ ના હોય અને જેટલી પણ આ સ્કાઇપની જે આખી એરેન્જમેન્ટ થયેલી હોય એ પણ સાહેબ બધી ફિક્ટિશિયસ એરેન્જમેન્ટ થયેલી હોય છે. હાલના અરજદાર જે છે આરોપી છે આપની સામે સાહેબ એમનું મેઇન કામ જે છે કે જે મેઇન કિંમતી સાવન તકરાર કરીને છે આ જે પૈસા જે આવતા હોય છે જે આવી રીતે વિક્ટીમ જે પૈસા જમા કરાવડાવે એ જે બેંક એકાઉન્ટમાં જમા કરાવડાવે એ બેંક એકાઉન્ટ ગમે તેમ કરીને ફેચ કરવાનું કામ હાલના અરજદારનું છે. પ્રાઇમરી ઇન્વેસ્ટિગેશનમાં અત્યારે એવું દેખાય છે કે ટોટલ એમણે મેઇન આરોપીને કે જેમની ત્યાં હાલના અરજદાર નોકરી કરે છે 25 થી 26 જેવા એકાઉન્ટ લઈ આપેલા છે. આવી રીતે ફેચ કરીને લઈ આપે છે જેમાં આવા વિક્ટીમના આવેલા પૈસા જે જમા થાય એવા 25 એકાઉન્ટ એમને લઈને આપેલા છે. ઇન્ટરેસ્ટિંગલી સાહેબ અત્યારે જે એમાઉન્ટ જે છે મીગર લાગે છે મને પણ સાહેબ જ્યારે ફર્સ્ટ ટાઈમ જોયેલી ત્યારે 2,92,000 જ છે પણ આવા જે બેંક એકાઉન્ટ હાલના અરજદાર આરોપી થકી જ્યારે ફેચ થઈને જે પૈસા આવે છે એ અલ્ટિમેટલી પૈસા રૂટ થઈને દુબઈ જાય છે અને એનું ટર્નઓવર જોવામાં આવે છે જે આ વોલેટ થકી જે થતું હોય છે મોકલનાર જે આ મુખ્ય આરોપી છે એના વોલેટની અંદર 9 થી 10 કરોડ જેટલી એમાઉન્ટ ટ્રાન્સફર થયેલી છે દુબઈ અને જે એકાઉન્ટમાં ટ્રાન્સફર થયેલી છે એમાં અરાઉન્ડ 200 કરોડ રૂપિયા જેટલું ટ્રાન્સફર થયેલું. એટલે પહેલી જે અત્યારે જે 8 દિવસ માટેની જે પોલીસ કસ્ટડીની માંગ છે ઇન્વેસ્ટિગેટિંગ ઓફિસરની એમાં મુખ્ય પહેલો મુદ્દો સાહેબ એ છે કે જે ખોટા દસ્તાવેજો બનાવીને જે સીબીઆઈ અને આરબીઆઈ ના ફરિયાદીના નામના ખોટા દસ્તાવેજો બનાવેલા છે એ હાલના આરોપીએ બનાવેલા છે કે કોઈ બીજા આરોપીએ બનાવેલા છે એ લાઈન ઉપર તપાસ કરવી જરૂરી છે. બીજી વસ્તુ સાહેબ જેટલી આ ખોટા જે બેંક એકાઉન્ટ એમણે ફેચ કરીને મુખ્ય આરોપીને આપેલા છે એની અંદર ઘણી બધી એપ્લિકેશન પણ ડાઉનલોડ થયેલી છે એટલે એ એપ્લિકેશન થકી પૈસા વોલેટમાં આવે છે યુએસડીટી જેને કહે છે અને અલ્ટિમેટલી દુબઈ જે થાય છે એ જે એપ્લિકેશન્સ બધી જે થયેલી છે એ એપ્લિકેશનની અંદર સિક્રેટ કોડ હોય અથવા તો બાયોમેટ્રિક હોય એ હાલના અરજદાર આરોપીની છે કે કોઈ બીજા આરોપીની છે એ લાઈન ઉપર સાહેબ તપાસ કરી ચાલુ છે. હાલના આરોપીને સાહેબ અત્યારે ટ્રાન્સફર વોરંટી નામદાર કોર્ટ સમક્ષ લાવવામાં આવેલા છે. જે મુખ્ય આરોપી સાવન તકરાર છે એ પણ સાહેબ એને ટ્રાન્સફર વોરંટી હજી લાવવાના અરેસ્ટ થઈ ગયા છે. એટલે સાહેબ બંને આરોપીઓ કે જે એક એમ્પ્લોયર છે અને એક એમ્પ્લોયી છે બંનેને જોડે બેસાડીને પણ આ જે બધા ટ્રાન્ઝેક્શન્સ થયેલા છે એ કેવી રીતે રૂટ કરેલા છે
એની સાહેબ તપાસ ચાલી રહી છે અને અલ્ટિમેટલી જે 200 કરોડ રૂપિયા વાળી સાહેબ જે મેં વાત કરી એ આ વોલેટનું એક એક્સચેન્જ હોય છે એ એક્સચેન્જની અંદર ડિટેલ્સ માંગતા ટોટલ 11,000 એન્ટ્રીઓ છે એની અંદર જે આ પર્ટિક્યુલર વોલેટમાં જેની અંદર 200 કરોડ રૂપિયા ગયેલા છે એની અંદર 11,000 એન્ટ્રી છે એ 11,000 એન્ટ્રી કેવી રીતે એમાંથી કેટલા રૂપિયા હાલના અરજદાર આરોપીમાંથી કેટલી ટ્રાન્સફર થયેલા છે એની પણ સાહેબ તપાસ કરવી જરૂરી છે અને જ્યાં સુધી આ ટ્રિગર ઓફેન્સની વાત છે સાહેબ ટ્રિગર ઓફેન્સની અંદર જે પૈસા એક્સટ્રેક્ટ થઈ ગયા પછી વિડ્રો કરવાની કામગીરી એ પણ આરોપીની છે વિડ્રો કરીને પછી એને આંગળીયા પેઢી મારફતે સુરત મોકલવાની કામગીરી એ પણ હાલના આરોપી અને બીજા સહ આરોપીઓની છે અને અલ્ટિમેટલી એ સુરતથી પૈસા દુબઈ જાય છે આખી જે સાઈડ આ ચેન છે એ એસ્ટાબ્લિશ કરવા માટે 8 દિવસના રિમાન્ડની જરૂર છે એક જે ગુનો હમણાં રિસેન્ટલી થયેલો છે જ્યાં સિન્ડિકેટના સામે થયેલો ટોટલ હાલના અરજદાર આરોપીની સામે 3 ઓફેન્સીસ રજીસ્ટર થયેલા છે ઇન્ક્લુડિંગ ધી પ્રેઝન્ટ ઓફેન્સ સિન્ડિકેટની સામે પણ 3 ઓફેન્સીસ રજીસ્ટર થયેલા છે જે હમણાં રિસન્ટ 2025માં જે સિન્ડિકેટની સામે ઓફેન્સ રજીસ્ટર થયેલો છે એમાં સિન્ડિકેટની ઓફિસની તપાસ કરતા પંચનામું કરતા સાહેબ 65 પાસબુક 158 ચેકબુક 45 ક્રેડિટ કાર્ડ 12 મોબાઈલ ફોન સિમ કાર્ડ 49 અને ડિગ્રી ને બધું છે ને 37,11,000 રૂપિયા રોકડા મળ્યા છે એની જે પાસબુક ને એ બધું મળેલું છે એની સાહેબ એક પોર્ટલ છે એનસીઆરપી કરીને છે જેને કહે છે નેશનલ સાયબર ક્રાઇમ રિપોર્ટિંગ પોર્ટલ જે સેન્ટ્રલ નું એક પોર્ટલ છે કે જે પાસબુક ચેકબુક ને એ બધું જે એમના આરોપીઓની સિન્ડિકેટની ઓફિસમાંથી મળેલું છે એ જ પાસબુક અને ચેકબુક ને રિલેટેડ 404 કમ્પ્લેન્ટ થયેલી છે પોર્ટલની 404 સાહેબ 8 દિવસ માટે હું પોલીસ કસ્ટડી રિમાન્ડ આપવા માટે રજૂઆત કરી ક્રેક ડોક્યુમેન્ટ્સ કોણે બનાવ્યા અને બીજા કોઈ આઈડી કે બીજા એકાઉન્ટ આ જે હાલના આરોપી જે આપેલા છે એ વિગત તો સાહેબ આ એટલે એ વિગત ખોટી છે આમાં ફક્ત આ ડ્રાઈવર તરીકે નોકરી કરતા હતા ડ્રાઈવર તરીકે પોતે કામગીરી કરતા હતા અને આમનો રોલ ખાલી એટલો જ છે કે એક સાવન ને લોકો આમને કહે કે આ એટીએમ માંથી આ એકાઉન્ટ માંથી આટલા કેશ વિથડ્રો કરીને લાવવાના છે એ કેશ લાવીને વિથડ્રો કરીને એમને મોકલતા હતા બસ આટલો જ રોલ છે આમનો આ સિવાય જે ડોક્યુમેન્ટ્સ બનાવવાની બાબત ને એકાઉન્ટ લઈ આવવાની બાબત એવી કોઈ બાબત આમને કોઈ સંલગ્ન કોઈ કામગીરી કે આમને કોઈ એવું ગુનાહિત પ્રવૃત્તિ કરી હોય એવું તો આમને આ જે રિમાન્ડર છે એમાં સ્ટોરીમાં નથી હોતું એટલે આમનો રોલ ફક્ત કેશ વિથડ્રો કરીને આંગળીયા કરી દેવાના સાવન કે અને એમને મોકલી આપવાના ડ્રાઈવર તરીકે સાહેબ કામ કરતા આમનું પોતાનું એકાઉન્ટ આમાં એમને કીધું કે એમને એકાઉન્ટ ખોલ્યા છે કે નહીં એકચ્યુઅલી આની અંદર રિમાન્ડમાં એવું માંગેલું કે આમના નામે પેલા લોકોએ એકાઉન્ટ ખોલીને કોઈ ટ્રાન્ઝેક્શન કર્યા છે કે નહીં એ બાબતે આપને તપાસ કરો આમના નામે કેટલા એકાઉન્ટ ખોલ્યા હોય આમને કેવી રીતે ખબર આમાં એ રીતની સાહેબ જો પેલા 4 માં પેલા 3 માં રિમાન્ડના મુદ્દામાં પેલા 3 માં શું લખ્યું છે કે હાલના આરોપીની આ ગુના સંબંધે કરેલ પૂછપરછમાં અગાઉ ગુનામાં અગાઉ પકડાયેલ આરોપી સાવન તકરાર ના હોય ફરિયાદીની ફ્રોડ એમાઉન્ટ એટીએમ થી કેશ વિથડ્રો કરી આરકે આંગળીયા પેઢી મારફતે ગુજરાત ગઢવીને સુરત ખાતે મોકલેલી તે રકમ યુએસડીટી તેના ઓળખીતા હસમુખ નસીબ પાસેથી ખરીદી પોતાના આઈડી માં મેળવી આગળ મિલન ચાવડા નામના આરોપીને મોકલી આપેલ હોવાની હકીકત જણાવતા હોય જેથી આરોપીએ યુએસડીટી પોતાના કયા ક્રિપ્ટો વોલેટ આઈડી માં મેળવીને આગળ મિલન ચાવડાને મોકલતા હતા આરોપીઓએ આ યુએસડીટી પોતાના કયા ક્રિપ્ટો વોલેટ આઈડી માં મેળવીને આગળના મિલન ચાવડાને મોકલતા હતા તે બાબતેની તપાસ હવે એ બાબતેની આમને કઈ ખબર ના હોય એમને તો આંગળીયા કરી દીધા હતા એટલો જ રૂલ
આમની ગમે તે મારીને પૂછપરછ કરશે તો એ નથી બતાવી શકવાના કે આગળ એ લોકો શું કરતા હતા, કારણ કે ટેકનિકલ એનાલિસિસ કરીને એ લોકો કેવી રીતે ત્યાં ક્રિપ્ટોકરન્સીમાં ફેરવતા હતા, દુબઈ મોકલતા હતા કે XYZ જગ્યાએ ટ્રાન્સફર કરતા હતા, એ બાબતે આરોપીને આને કોઈ જાણકારી નથી. આની ખાલી પ્રાથમિક પૂછપરછ
મારીને પૂછપરછ કરશે.
એટલે હું એટલું જ કહેવા માંગુ છું કે આ જે મુદ્દાઓ આમાં રિમાન્ડ માટે જે માંગેલા છે એ મુદ્દાઓ બાબતે જયારે એની જાણકારી એની જે જેટલી જાણકારી હતી એટલે આ આપી દીધી છે કે હું કેશ વિથડ્રો કરીને મોકલી દેતો, બસ એટલો જ એનો રૂલ. આ જે હાલની અરજી પ્રમાણે પણ એટલે ફેક એકાઉન્ટ સામે ઉભા કર્યા છે કે કેમ, તો જે એ ડોક્યુમેન્ટરી એવિડન્સ છે એ તો સાહેબ અગાઉ જે ગુનાઓમાં આટલા સિન્ડિકેટના મેમ્બરો પકડાય છે, બીજાની પૂછપરછમાંથી આમના નામ ખુલેલા છે. એ પહેલા પહેલામાં એ રીતનું આખી સ્ટોરી એ રીતનું છે કે જે પકડાય જે ફરિયાદને આધારે એમાં જે પેજ નંબર 2 માં છે એમાં ચોખ્ખું લખ્યું છે કે સંડોવાયેલ આરોપી સાવંત ત્રિભુવનદાસ ઠકરાર પરિમલ ગાર્ડન પાસે એલિસ બ્રિજ નાઓને ટ્રાન્સફર વોરંટના આધારે મેળવી તેને ગુનામાં 3/8/25 ના રોજ પકડીને અટક કરવામાં આવેલ છે. આ આરોપીની પૂછપરછ દરમિયાન અને તપાસ દરમિયાન તેની સાથે ગુનો કરવામાં 4 નામ આપેલા છે. એમાં ધવલ ઠકરાર, કેવલ ગઢવી, બ્રિજરાજસિંહ ગઢવી અને આ ગોવિંદ ભુરિયાલાલ રાવલ, હસમુખ ઉર્ફે હિતેશ એ નામના વ્યક્તિઓ મદદગારી કરેલ હોવાની હકીકત મળી આવે છે. એટલે સાહેબ કો-એક્યુઝના સ્ટેટમેન્ટના આધારે 4-5 જે નામ મળ્યા એમાં સાહેબ આ ડ્રાઈવરનું નામ આવી ગયું અને આ ડ્રાઈવરનું સાહેબ એમને 24 કલાક અમે એ જે અત્યાર સુધી એ કસ્ટડીમાં જ હતા અને દરેક જે મેટર્સ છે એ મેટર્સમાં ખાલી રકમો બદલાઈ છે, મોડસ ઓપરેન્ડી ને આ જે હકીકતો જે છે એકાઉન્ટ ક્યાં એકાઉન્ટમાંથી ક્યાં એકાઉન્ટમાં ટ્રાન્સફર થતા એ તો સેમ છે. એમાં દરેક એફઆઈઆર માં અલગ એકાઉન્ટમાંથી અલગ મોકલેલા છે નહીં, દરેક એફઆઈઆર માં જે ટ્રાન્ઝેક્શનો આરોપીઓએ કરેલા જે બતાવે છે સિન્ડિકેટ તરીકે એના ટ્રાન્ઝેક્શન તો સેમ જ છે. એટલે એની તપાસ જેટલી નવી એફઆઈઆર થશે કે જેટલી જૂની એફઆઈઆર છે બધામાં આ ટ્રાન્ઝેક્શન છે ખાલી રકમ બદલાય તો સાહેબ તપાસ કરતા એજન્સી તો સેમ છે સાહેબ, ખાલી સિટી બદલાઈ છે અને કસ્ટડીમાંથી લઈ આવ્યા છે. તો આ જે મુદ્દાઓ જે સંલગ્ન લાગે વળગતા નથી આ આરોપીઓની સાથે સંલગ્ન નથી થાય. એ જે આરોપીઓની પાસેથી માહિતી મળી જે આરોપી સાથે કનેક્ટેડ છે એની માહિતી સાહેબ ફરીથી આમની પાસેથી કઢાવવા માટે રિમાન્ડ આપવા યોગ્ય નથી. સેમ ટુ સેમ સ્ટીરિયોટાઇપ સાહેબ એમાં આ રીતના રિમાન્ડ માટેની એપ્લિકેશનો હશે. આમના રોલ પૂરતું કોઈ ટેકનિકલ એનાલિસિસ કરવાનું બાકી હોય કે કોઈ જાણકારી મેળવવાની બાકી હોય, બધા કસ્ટડીમાં જ છે ને કસ્ટડીમાંથી જ ટ્રાન્સફર વોરંટના આધારે એક બીજી જ્યાં એફઆઈઆર થાય ત્યાં આગળ ટ્રાન્સફર કરીને સાહેબ રિમાન્ડ માટે લઈ જવામાં આવે છે. ત્યાંની એજન્સીઓ તપાસ કરે છે. એટલે આમાં કોઈ મુદ્દા એવા સ્પષ્ટ જેટલા મુદ્દાઓ રિમાન્ડના આપેલા છે એમાંથી એક પણ મુદ્દાઓ એવા નથી કે સાહેબ 8 દિવસના રિમાન્ડ આપવા પડે, કોઈ ડોક્યુમેન્ટરી એવિડન્સના આધારે સાહેબ રિમાન્ડ ના આપી શકાય. કે જે ડોક્યુમેન્ટરી એવિડન્સ રિકવર કરી શકાય હોય ત્યારે સાહેબ આરોપીની હાજરી જરૂર નથી.